Excellent. Thank you very much for coming. Sorry, I've just lost my screen at the wrong moment. Welcome to this session, which forms part of Getting on Board's Trustee Learning Programme. My name is Fiona McCausland. Today we are talking about employing your first member of charity staff. Before I hand over to Carla Whalen, I will just cover some housekeeping. Feel free to introduce yourself in the chat and tell us why you've come today. This session will be recorded. You'll get access to the recording and any slides used following the session. We're probably going to add the recordings to YouTube within the next sort of month or so you'll be able to access it there as well. Please stay muted on the call unless asked to unmute. It helps to make sure that everybody can hear who is talking clearly. We do have closed captions available, which you'll need to enable at your end. And please use a chat to ask questions and to share experiences. No question too small, too big, too silly, just please ask away. We'd love to hear from you, and please keep your comments respectful and useful. Thank you very much to our sponsors, Russell-Cooke, for supporting the Trustee Learning Programme. Carla will say a couple more words about Russell-Cooke in a moment, but thank you to them. Their support allows us to make this session and the whole programme free to attend, which really supports our mission of making sure that quality trustee learning is available and accessible to as many people as possible. I will now hand over to Carla, who is leading today's session. Thank you, Carla.
Thanks, Fiona. Hello, everyone. I should say, if it's not immediately obvious, that I'm just getting over a cold and I've lost my voice a little bit. It's actually much better than it was a few days ago, but you'll have to excuse this slightly husky tone of voice. As Fiona said, I'm very, very happy to take questions as we go. Type them in the chat. I will try and pause and check the chat from time to time. I'm going to share my screen with, I've got a couple of slides. So hopefully you'll now be able to see the slides. Great. So broadly speaking, I'm going to kind of take today's session in two parts. The first part is going to be thinking about making the decision to employ your first member of staff. Is it actually the right decision? Might there be alternatives that the charity might want to think about? What might those be? What kind of factors might you take into account when deciding whether an employee is the right kind of route for you at this time? And then in the second part of the session, I'm going to assume you have decided you want to employ someone, and we're going to talk about the more practical side of the kind of questions about how you do that effectively, both from a kind of legal, regulatory perspective, but also from a slightly more kind of employee relations, HR, hands-on sort of aspect as well. So I'm a partner in the charity team at Russell-Cooke. My background's in employment law, and I joined the charity team about, I suppose, 6-7 years ago now. So I've been working solely with charities now for quite a little while. I'm also a trustee myself of a smallish charity. And a lot of our clients are smaller charities, particularly when I say smaller, smaller from a staff perspective. So actually some organizations might be large if you measure it based on financials. So for example, a grant making charity with a large kind of endowment or something, but actually they might have very few members of staff, might possibly have no employees. So it's really interesting. I think the charity sector, you wouldn't necessarily be able to guess which of the charities are large from an employment or staff perspective, just from looking at the size of their kind of income or financial turnover. So I am assuming that most of the people on the call today are trustees of smaller organisations that don't currently have employees. I know a couple of people have introduced themselves and said they might be coming at this from a slightly different perspective, maybe as an advisor themselves, and that's totally fine. I think it would be really interesting when we're in the chat and the questions later, we can bring in a variety of kind of perspectives. So the first thing, as I said, we're going to think about is putting yourself in the position of a charity trustee, and as collective as the board. How do you know that you're ready to employ someone? Typically, from my experience, it comes about from the perspective of operational needs. So often a charity or a not-for-profit organization will have started quite small, perhaps just purely voluntary. Perhaps the board are also the only volunteers, and perhaps also include the founder. Or there might just be a few more volunteers helping out. And at some point, the operations become too big or too complex to reasonably ask volunteers to take on that time commitment or the responsibilities of running an organization. And those responsibilities are often kind of legal responsibilities or things like safeguarding. So, the classic is a Saturday football club or something. Actually, when you realize that you're an unincorporated association and you've got all these health and safety duties and safeguarding duties, if you're working with children, actually for volunteers running it might be that there are all sorts of reasons why they realize that it's just too much of an ask. Sometimes we talk to charities that have casual staff already. So they might be casual workers, and we'll come back to talk about the difference between employees and workers in a moment. But they might have, some people who do bits and bobs, or who are doing work on a kind of consultancy, self-employed basis. Again, we'll come back to that in a moment. And it's more about needing a more reliable and stable workforce, so you can be guaranteed that someone is there when you need them. And then the flip side of that is that sometimes the decision is made because of more of a kind of regulatory or legal consideration. So often that is this employment status test that I've put in the bullet point here, what the law calls the irreducible minimum that helps you decide whether someone is actually an employee or not. And I think what sometimes comes as a bit of a shock to people is that the decision from a legal perspective about whether someone is an employee or not isn't actually made based on what your contract says, or solely based on what your contract with them says, or what your paperwork with them says, or what you've agreed with them. It's based on the facts of what's actually going on the ground. So we do sometimes talk to charities who don't think that they have any employees, and we have to break it to them that they might, based on how the arrangements are working in practice. And unfortunately, the kind of employment status test isn't massively black and white. A number of factors can be taken into account. And there have been some recent cases, a lot of them dealing with what we call the gig economy, so delivery riders, Uber drivers, that sort of thing, where exactly this question has sort of been asked. These people have been engaged ostensibly as self-employed contractors, but actually based on how they work and the arrangements in place, that might not actually be the case. So when I talk about the irreducible minimum, this isn't a session today about the test for employment status. So I'm not going to go into lots of detail, but the things to bear in mind are the three key factors. Is the person required to provide a personal service, or could they send a substitute or get someone else to do the work for them? So a really classic self-employed situation is something like you have a project that you want doing. So you need someone to paint your living room. You don't care who actually puts the paint on the wall. You just want it to be done to the requirements that you need it to be done. That's a kind of classic self-employed situation. You just say, you give me the end result and I don't care exactly who or how it's done. The second thing, so personal service is one thing. The second thing is control. So in an employment relationship, the employer parties, the charity here, exercises quite a high degree of control over the individual. So that's things like you set specific days of work, you set specific hours of work, you have policies that apply to them beyond things like health and safety, policies like conduct policies, performance management policies, disciplinary policies, those kinds of things. You have appraisals with this person, you set targets for them. That kind of level of control is much more towards points much more towards the end of and the employment end of the scale versus someone again who can do the work whenever they want and however they want, as long as they deliver the services you need in the timescale that you need. And then the third thing, so we've had personal service and control. The third thing is what's called mutuality of obligation. So that's basically the extent to which each party expects work to continue to be offered and expects the person to accept the offer of work. So effectively, in an employment situation, you expect that you'll still have a job next week and next month and next year. It's an ongoing relationship. And in return, the employer expects that their member of staff will come to work, continue working, subject to obviously termination clauses, notice periods in the contract, and stuff like that. But generally speaking, there's that mutuality of obligation. The flip side is that with a self-employed situation, it tends to be more project-based, short-term, perhaps, less of an expectation that there'll be an ongoing relationship or that the work will just keep flowing. So, so I think sometimes what we end up talking to smaller charities who don't necessarily plan to employ someone and would actually prefer to have people engaged on a self-employed basis. But the law means that because of the arrangements they have with those people, it's actually quite likely those people might be classed as employees in any event. And the risks, if you don't recognize that, are mainly that the individual could bring a claim against you saying, actually, you were my employer, I was your employee all along. So let's say they've worked for you for a few years and you decide you don't need them anymore. You give them notice in accordance with their contract because you think that's all that's required. And they say, I was unfairly dismissed. That's going to be news to you that you had to go through a process before dismissing them and have a fair reason for dismissing them, as you would with an employee. Similarly, they might claim holiday pay, sick pay, the things that you wouldn't, the benefits that you wouldn't give to someone if they weren't an employee. There's also a tax risk. If you're not treating someone as an employee, you're not taxing their income through PAYE in the way you would with an employee. So there's also a risk that HMRC could come and say, actually, that person was in fact an employee. Now, the risk of HMRC actually doing a proactive audit of a small charity is actually pretty low, but it is a risk that's there. So those are basically the two reasons why we see small charities typically deciding it's time to move to having an employee. So I'm just going to have a look at the chat. Yeah, there was a question about when I talk about consultancy or self-employed, does that include freelance? And yeah, usually the answer is yes. Typically when people talk about freelance, they mean contractors, they mean self-employed people. Freelance doesn't have any meaning in law, but usually freelancers are engaged on a self-employed basis. And sometimes the easiest way to find out whether we're talking about employed or self-employed is to look at how you tax their pay. Are you taxing them through PAYE or not? And if you're not, if you're just paying them a fee and it's up to them to declare their own tax through an annual tax return of their own, that's indicative of a self-employed or consultancy type arrangement. So thinking about if you are deciding whether employment is the right route to go down. What other alternatives might you think about? Well, we've already talked about volunteers and the sort of limits of um, running an entire charity based only on volunteer time. Unpaid interns, they are volunteers effectively, or they should be. Again, if you don't have a proper intern agreement and arrangement in place that makes clear it is a voluntary arrangement, there could be a risk that your intern turns around and says, actually, on the facts of how we're working together, I'm your employee. But a proper internship is basically just volunteer. We talked about self-employed consultants, freelancers, whatever you want to term them. That can be an agreement direct with the individual, the consultant, or it might be an agreement with a company that provides them. They're typically called personal service companies. So if I set up Carla Whalen Limited to provide the services of Carla Whalen, it's that kind of arrangement. Some of you might know that if you're using that type of arrangement where you're engaging someone through their own company, there's some tax guidance and law that comes into play called IR35 that you need to think about. But again, that could be a whole topic for a different seminar. You can have casual workers. Now, just as I was saying that the legal test for employment status can be a bit confusing and difficult to give a definitive answer, the test for worker status can be equally grey and difficult to be completely confident about. So the employment legislation talks about there being three categories of workers, three categories of staff, essentially: employee, worker, and self-employed. And the difference between an employee and a worker is the absence of that mutuality of obligation. So a worker is typically your kind of really proper casual staff, bank staff, 0 hours staff. There's absolutely no expectation that if you offer them work, they must accept it. It's up to them whether they take on the offer of work or not. And equally, if you don't have any work for them, there's no requirement or expectation that you will give them work to do, paid work to do. So casual worker is a status that's different to employment. But as I say, there is a bit of a risk that casual worker arrangements can, over time, become employment arrangements. Because you start off just saying you can work for us if you want, but you end up falling into habits of, oh, they work every Wednesday and Thursday. And you can see over time they might become an employee without you realizing it. Excuse me. Agency staff can be a good option. It's more expensive usually, but effectively the agency is the employer. So you kind of outsource all of the employer obligations to the agency and they provide the staff for you. If the staff aren't performing very well or you're not happy with them, send them back to the agency. Agency has to address that. Secondment could be an interesting one. You might have an arrangement with another charity or with a business where they second one of their employees to spend some time working for you. Again, the other organization, the charity or the corporate, they are the employer. You have an agreement with them for them to provide the secondee to you. And if there's any problem, basically goes back to them to sort it out. Again, it can be useful, but ultimately they're not your employee. You don't control them. And it's usually a short-term arrangement. Might be a year or so, but it's not long term. And then the final one that I just wanted to mention was employer of record. which is a relatively new concept in the UK. I think it's something that's been more common in the US for a while, that these are companies that will offer you the option of them being the employer sort of on your behalf. It's really common where organizations have a member of staff overseas and the organization doesn't want to set up an office in that overseas country, doesn't want to go through all of the legal, tax, regulatory bother of working out what local employment law and local tax law is. So they'll use one of these employers of record. Now, because it's quite a new concept in the UK, from a legal perspective, I think it's fair to say there's quite a bit of skepticism about exactly how this would work. If someone were to bring a claim saying the employer of record was just a silent partner, we never saw them, we had nothing to do with them, and they didn't actually manage our day-to-day work. In fact, the charity is our employer anyway. So if you're going to use an employer of record, what's really important is that you pay attention to the contract terms you have with that company, because you want to be protected if the individual employee turns around and says, you didn't know it, but you're actually my employer after all, and I want to bring a claim against you. So as I say that kind of almost for completeness, but again, it's quite expensive. So probably not something that small organizations would go for. There's a couple of questions in the chat. So one person says, we've got volunteers and we have a rota where there's an expectation that the volunteer will turn up and help out, or sometimes even do overnight shifts at supported accommodation. There's no pay, there's no expectations that they'll perform to a certain standard, but they do need to comply with policies like health and safety. So the question is that a genuine employment relationship? So is that a genuine volunteer relationship? And, you know, unfortunately, with these kinds of questions, it sort of depends. On the face of it, if you're saying there's no expectation that they will sort of, you know, have to continue working for you, you know, next week, the week after, then simply having a rota for volunteers isn't going to be enough to push them into the employment sphere. You know, if you are running a charity shop and you need volunteers to work on specific days at specific times, or volunteer at specific days and specific times, just so you know that the shop can open, that's fine. That in itself isn't going to tip you into the employment side. If you were offering them any kind of benefits, if you were having appraisals with them, performance managing them, then that's the kind of thing that I would sort of stop and say, is this truly a voluntary relationship? If you were paying them more than receipted expenses, that might be the kind of thing that would make me stop and say, be a bit careful. But if it is purely a kind of, you know, week to week or fortnight to fortnight, you agree a rota, and volunteers don't have to, you know, always be on the rota. It's just whoever is available to be on it at that time, and there's no pay, and the only policies they have to comply with are the kind of legal policies like health and safety. I think you're fine. There's also a question about temp to perm positions. And again, it's really factual, these questions. If you engage someone on a temporary basis, that doesn't mean they're not employees. You can have fixed term employees, you can have temporary employees. It's a much wider question about, you know, what are the arrangements with that person? So even if someone's engaged on a fixed term or temporary basis, they might still be an employee from the start. So thinking about, if you have decided that you're going to employ someone, you're pretty sure that that's the route you're going to go down. From a legal perspective and a regulatory perspective, what things do you need to have in place before you go down, you know, take the leap? Well, you need to have contracts of employment with the individual, and that's written contracts, and that's really non-negotiable, because I put on the slide here Section 1 of the Employment Rights Act. And Section 1 is quite prescriptive about exactly what needs to go in a statement between you and that you give to your employee. And the statement, or sometimes called a Section 1 statement, is effectively the contract. So there are certain things that have to go in the contract. So pay attention and make sure that the contract you're using reflects the requirements of Section 1. Those requirements were updated a few years ago. So if you've got old template employment contracts, or you're being given a template from somewhere, and maybe it's a template that's 3+ years old, just be a bit cautious and make sure that it does actually contain everything it now needs to contain under the updated Section 1. And the other thing is core policies, employment and HR staff policies. So I've mentioned kind of HR policies here. Again, Section 1 of the Employment Rights Act says that you must give people certain information. And if you don't put that information in full in the contract, you can give it to them in a separate document. So that's typically things like disciplinary procedures, grievance procedures, sickness absence, and sick pay procedures. They can be given in a separate document, and usually they are. Usually you don't have the whole procedure in your contract, partly because it makes the contract quite unwieldy and long, but also from a legal perspective, you don't want every step in your disciplinary procedure, for example, to be contractually binding, so that if it took you more than 3 days to arrange a disciplinary hearing, you can't be sued for breach of contract. You want it to be in a separate document. So you'd have these employment policies that sit alongside your contract, usually in a staff handbook. So I've mentioned disciplinary, grievance, sickness absence, sick pay. The Charity Commission also says that charities should have a safeguarding policy, and that you should have a whistleblowing policy for your staff as well. You probably also want to have, and you might have some of these in place already, depending on what your staff structure already looks like, or volunteer structure, but you'd also want to have equal opportunities policy, or equality and diversity policy, whatever you call it. You'd want to have probably kind of anti-harassment bullying policy, or you might call it a code of conduct and wrap it into that, whatever you call it. You probably want something along those lines. And then you probably also want a data protection policy, which tells staff how they're expected to handle personal data and what to do if they think, for example, there's been a data breach. And quite a few charities now want a social media policy, not least because the Charity Commission just recently put out some more detailed guidance on social media, and how charities are expected, or how the regulator expects charities to use social media. So in addition to those HR policies, I've mentioned here health and safety policy and safeguarding. So from a legal perspective, if you've got 5 or more employees, you're legally required to have a health and safety policy. But frankly, even if you've got fewer, you probably want one anyway. It's probably a good idea to have one. And it's possible that your insurance cover might require you to have certain policies in place, including a health and safety policy. You are required to have insurance, as I've mentioned, employee liability insurance. So as soon as you become an employer, you're required to get at least £5 million employee liability cover. And the law says that needs to come from an authorised insurer. We talked a little bit already about tax. So if you are the employer, so you're not using one of those arrangements like a secondment, or an agency situation, or an employer of record arrangement, you are the one that's actually directly employing the staff. You're going to need to register with HMRC so that you can process pay through the PAYE system. Some small charities have arrangements either with an external payroll provider or with some sort of sometimes charities get together and agree that they'll have shared services with another charity. So if you're very small and the burden of running payroll, including all of those things like holiday pay, sick pay, maternity and family leave benefits, it can become a bit onerous if you only have 1 or 2 employees. Some small charities look at options for um, using shared services, working with another organisation to provide those payroll and benefit services. And then finally, don't forget pensions. So auto enrolment legislation, as it's called, came in quite a long time ago now. So even the smallest organisation is past what was called the staging date. So now pretty much all employers are going to have to auto enroll staff into a qualifying pension scheme. Now, some staff earn under the limit for doing that. So if it's very low paid staff, you might not need to. And there's also age requirements or kind of provisions relating to pensions. There's also a small kind of window at the beginning of employment where you don't have to automatically enroll someone on day one. But if you're going to employ someone, you should, before you do that, look into pensions and how you're going to provide a qualifying pension to people who are entitled to it. There are also quite strict rules about employers not being able to encourage or incentivize staff to opt out of a pension. So that can be an offence if you were to say, for example, well, there is this auto enrolment legislation, but if you opt out, we'll pay you an additional £1,500 a year in your salary. You can't do that kind of thing. So there's a question in the chat from Emily about what's considered to be a small charity. That probably depends on which requirement you're talking about. Emily, I don't know if you're able to put your microphone on and just clarify which part of what I've been talking about you were wondering about that definition. Well, we can maybe come back to that. I mean, if it's in relation to IR 35, then the definition of small comes from the Companies Act. If it is, as I say, for health and safety purposes, for example, then the definition is under 5 employees. But you need to be careful that there's no different bits of legislation and different requirements might define a small organisation in different ways. Okay, so moving on to look at salary and benefits. So as a board, you've decided you are going to employ someone. What do you pay them? And here I think I've tried to kind of summarize the main things that I think a board should be thinking about. The first one is straightforward. You have to pay the national minimum wage. You might also, as a charity, think about whether you want to pay above that and pay the living wage, or if you're in London, the London living wage. And that might be reputational considerations that you take into account there, that you want to be seen to be paying the living wage. It's possible that depending on what kind of work your charity does, if you have, for example, contracts with local authorities or public sector bodies, or your funders come from somewhere else, it's possible your funders might actually require you to pay living wage. You need to, think about that as well. But moving beyond just, I think, the bare minimum, when you're thinking about setting salaries and by extension employee benefits, you want to make sure that you're competitive enough, that you can attract good talent and then retain them. But you also need to kind of temper that by thinking about your trustee duties. And these are, the fundamental trustee duties that go for any financial decision making on the board. You need to think, how would we justify the use of this money as being in the best interests of the charity and to support the charity to carry out its purposes? So, I mean, I think somewhat unfairly, senior executive wages in the charity sector can be a bit of a touch point. And sometimes the sector press in particular can pick up on what it thinks are maybe out of whack salaries. As I say, from a personal point of view, I sometimes think that's a bit unfair. But ultimately, from the Charity Commission's perspective, if somebody said to the Commission that they thought a charity was just paying an employee far too much money, and that maybe the charity, either was a bit of a sham for someone to pay themselves a big whacking wage and extravagant benefits or something, um, the Commission would want to see some evidence that the board had thought about how they were pitching the salary and benefits for that employee. And the final bullet point on this slide suggests, one way of doing that is to benchmark salaries. And you might do that by using charity sector tools or reports. So you could use Charity Job, Akivo, TPP. They have various tools that you can use. Sometimes you need to be signed up with them to access those sector pay reports. The other kind of option is to just speak to similar organizations if you have good relationships with other organizations working in the same area as you, or a combination of these things. You could use recruitment websites. So go and have a look at, Indeed or Reed or Glassdoor or someone like this, websites that kind of collate information about salaries. And then, as long as the trustees can demonstrate that they've thought about benchmarking the salary as being reasonable for that role in the sector, in the geographical area, and they've thought about, why do we need to pay this in order to attract and retain the person that we want, then you're probably pretty safe from kind of criticism if it comes about how you've set salaries. And I think obviously a lot of considerations when you're deciding how to set salaries will inevitably be guided by resources. How much money do you actually have? Okay. So I just checked the chat, and thanks, Emily, for confirming. I think we've answered your question about, what's a small charity. So a couple more slides before we open it up to a bit more of a conversation and some questions, turning really to less of the legal and regulatory requirements and more to the question of, if you're going to have employees for the first time, how do you make it work? Once you've got them in the door, how do you make it work well? And there's a whole raft of things that really need to be in place, ideally before you even go out to recruit, but certainly before the person starts. So you need to make sure that you've got the right equipment and a good working environment for that person. Now, it might be that the working environment is an office that you have, in which case, are you satisfied that the person has somewhere to work? Is it suitably confidential if they're working in a role that's going to require them to have meetings or make calls or do Zoom or Teams meetings? Might you allow them to work from home? In which case, are you going to provide a satisfactory and safe place for them to work at home? Do they have a satisfactory place to work at home? Hybrid working is increasingly becoming the norm. So a combination of office and home working. And that's more about setting expectations at the outset, making really clear what your hybrid working arrangements are, how often you will expect the person to work from the office. Supervision and support. Who is going to manage this person? Is it a particular trustee going to be assigned the role effectively of line manager? What support is going to be provided to the person if they're your first employee? And then sitting down with them at the outset, setting targets, communicating expectations to them. That might be having a formal set of goals and targets, but also just providing that regular check-in, regular feedback, identifying any training and development needs, monitoring their performance in a kind of holistic way. From an employment advisor perspective, sometimes what we see, particularly in small charities where there's maybe only one or two employees, is that there are performance concerns, but they go unaddressed because no one is really managing that person. Or they might not even just go unaddressed, they might go unnoticed until things get to a point where you can't bring it back and we're actually being asked to just help you as the charity get rid of an employee. And that's always a bit sad because it's a lot of investment, not just money, but time as well, in recruiting someone, onboarding them, bringing them in, getting them trained up. And so, you need to be ready to continue that investment after day one. In most cases, you can't expect someone to come in if they're new to your organization, hit the ground running, and not receive any support or supervision. And then having kind of more formal processes, I think, is really helpful in providing a forum or an opportunity where both sides know that you're going to come together and talk about what's working and what's not working. If you don't have in the diary maybe one or two formal appraisal meetings per year, it's very easy to put it off and to not have those conversations. Or if you do decide you need to have that conversation, for it to feel like a massive thing because it's coming out of nowhere. If you have those formal appraisal processes, it's really helpful to just give a space for both sides to reflect and have hopefully quite an honest conversation about what is and isn't working. So I'm going to take a couple of questions. One of the questions is about whether there's any free templates or employment agreements or policies that might be suitable for small organizations. I think the answer is undoubtedly there must be a lot of them out there. I think a lot of membership bodies, umbrella bodies, provide this kind of service to their members. So things like NCVO, for example, provide a lot of really helpful, certainly guidance and support. It might be that your particular charity works in a specific area where you have a sector body that can help you, whether it's the care sector or education sector or something. I see Alex in the chat has just suggested the Charity Excellence Framework that has a big collection of really great sample templates. So yeah, maybe if others on the chat already know of a great resource, then they can share that. The other question that's come up is if a founder is establishing a CIO, so a charitable incorporated organization, with a view to serving as its paid CEO, what are the kind of opportunities and pitfalls? Should this be avoided? Can it be done successfully? Actually, in a moment, I'm going to come on to talking about the transition to employee from another role in the organization. So I'll come back to that just in a second. So It's really, really common in small charities for the first employee to be someone who is already engaged with the organisation in one way or another. It's actually not that common for a very small charity for its first employee to be a complete stranger, to go out and recruit. Not unheard of, but in our experience, it's much more the case that charities will come to us and say, we have someone who's already volunteering, or we have someone who's working for us as a consultant, or someone who's already on the board. There are some practical considerations and some legal considerations and regulatory considerations that you need to make sure you take into account. So if someone is transitioning from volunteer to employee, in some ways, that's probably the simplest from a kind of regulatory perspective. You obviously need to sit down with them and agree how the arrangements are going to change and make it clear to them that as an employee, they will be required to work at certain times and days, so they understand what it means for them in practice to be transitioning from volunteer to employee. But really, from a regulatory perspective, it's just a case of issuing that person with a contract of employment and with the relevant documents and kind of, making that change. When you're talking about someone transitioning from self-employment to employment, again, from a practical perspective, I would suggest you sit down with that person before that change is made and make sure that both sides understand what's going to change when that person becomes an employee. It's possible they might not have as much freedom to refuse work or to work flexibly in terms of flexible hours. It's possible you might need to think about potential conflicts of interest. Sometimes consultants work for a number of organizations, or at least they want to have the ability to be able to work for a number of different charities or organizations or clients. And if someone is your employee, you might want to limit how they can do that. And you might want to think both from the perspective of managing conflicts of interest, but also from the perspective of the time that you're going to be expecting them to dedicate to their job as an employee. You might want to put restrictions in the contract of employment to say either you won't work for anyone else without our prior consent, or at the very least, you'll inform us if you're going to work for someone else. And we need to make sure there's no kind of conflict of interest. Also, from a kind of thinking right back to when we were discussing employment status and the risk that the arrangements you have with someone might actually, in practice, make them an employee, even if that's not how either of you have been thinking about it. If someone is transitioning from being self-employed to employed, ideally, the relationship and the arrangements would change. Because if, in fact, the difference between the person being a consultant or a freelancer and them being an employee is zero, then obviously that creates a slightly higher risk that the person can say, well, I was always an employee then, nothing changed. Whereas if you can say, well, previously it was very casual, or it was short-term based, you worked for a lot of different people, we had no control over you, you didn't have set days. When you became an employee, you were now required to work these days, these hours. We set targets for you, we did appraisals with you, etc., etc. It really reduces those legal risks that someone could say there was no difference. Moving from trustee to employee or board member to employee can be a bit more complex. Mainly, as I've kind of flagged on the right-hand side of this slide, you may need to go to the Charity Commission to get consent. Specifically, if you are going to employ someone and you want them to continue being a trustee, you'll need to get the consent of the Commission. But even if someone is going to step down from the board and immediately become a paid employee, you still need to go to the Commission and get consent. There's guidance on the Commission's website about this, and I don't pretend to be a charity governance expert, but I work with lots of people who are. So if you're at all unclear about whether you need to get consent before employing someone who is or has recently been on the board, I'd really strongly advise that you take some advice. It shouldn't be a massively complicated piece of advice. And the benefit to the charity in getting that right is pretty significant, because if you end up paying a trustee in circumstances where you weren't actually authorised to do that, and you've been doing that for a bit of time, then it can get you into difficulties. And what the last thing you'd want is for the Commission to be getting into any kind of territory where they were talking about, should individual trustees be repaying the charity funds that weren't authorised to go out, and that sort of thing. That's quite an extreme end of the scale. But the Commission can't really give retrospective authorisation, so you really need to think about that up front. Same goes for connected people. So I've listed there what a connected person is. If you're employing or proposing to employ someone who's connected to a trustee, you might also need Charity Commission consent. I think from a more practical perspective, when we're talking about people being employed and also being on the board, there's a big kind of question about making sure that you deal with managing potential conflicts of interest up front, that everybody is clear about which hat you are wearing when you're making certain decisions. And it can be a bit complicated when certain topics are being discussed by the board and decided on by the board. If there's someone in the room who is both a trustee with all of their trustee duties, and if you're also a company director duties, but they're also an employee. So I think if you do want to think about having someone who is an employee and on the board, definitely I would suggest really considering that carefully, the pros and cons, and whether there's any kind of, as they say, regulatory need for you to go and get prior consent. So, couple of questions on this kind of slide and on this question of moving from trustee to employee in particular. Question about what would a recent board member be? Is there a set time limit? Again, as I say, this really isn't my kind of core area of expertise, but I think the answer is no. There's no kind of guidance that the Commission puts out that says if you've been off the board for 6 months, then you don't have to get Charity Commission consent. I think we tend to advise clients to kind of err on the side of caution if it's a relatively short time. But that said, I know there's been situations where a charity's asked us, if someone was a trustee a couple of years ago, we want to employ them. At the very least, I think that the board would want to have noted in the minutes that it considered whether you needed to get consent, that it referred to the relevant Charity Commission guidance, and you made your decision that you didn't need to based on that guidance. Because as with so many things, when it comes to regulators, even if the regulator came in and did take a different view, if they can see that the trustees asked the right questions, looked at the relevant guidance, applied that guidance reasonably, and arrived at the conclusion that, okay, there's nothing in here that makes us think we need to ask for consent, at least you're on pretty good footing to be able to explain to the Commission why you took that decision. It's much less likely that you're going to be criticised. So, as I say, ideally, if you're recruiting someone who's been on the board in the last few years and you're going to pay them as an employee, I think I would suggest you take a bit of advice or check that out. But at the very least, I'd suggest that the board makes a note in the minutes that it considered the relevant guidance, considered whether it needed consent, and notes why you decided not to based on that guidance. Okay, so the last slide, just before we finish up, I've just put here a couple of considerations for the board as well. I think as well as the transition for the employee, the board needs to adjust as well. And the good news for getting on board subscribers is that I actually took part in a panel discussion for getting on board last week, where we talked about managing the relationship between the staff and the board. And that's a really great resource if you have a look at that for some really practical considerations about making really clear what the role of the trustees is and what the role of the staff is, and trying to avoid problems that can arise where that's not clear and where either side feels like toes are being stepped on. So I think the main thing is make sure the board also adjusts and realizes it's going to hand off operations to the member of staff, and then make sure that the board is getting the reports it needs so that it can still monitor the finances, the risk factors, and the activity of the organisation. So that brings me to the end. I'll stop sharing. I think we've taken a lot of questions as we've gone, and I'm not sure if there's anything else in the chat. I don't think there is.
I think you've captured it all, Carla. Just that was brilliant. I've taken loads of notes. Thank you so much. Yes, if you do have any more questions, you can always kind of email, ping them over on info@gettingonboard. And I've just put into the chat the evaluation form. Please do fill in the evaluation form. It really helps us deliver more sessions. Please have a look at the other sessions we have in our free trustee learning program that's available on Eventbrite. Have a look at our website, sign up for our newsletter. Alex has their hand up. So I'm just going to ask you very quickly, Alex, if you can unmute. We've got about 40 seconds left before we need to end. If you want to unmute very quickly, if you want to.
I'll do it very quickly. Thanks so much for today, Carla. Really helpful. So it basically explained a lot. What I assumed was that employing someone is quite complicated. Do you have a recommendation for what is an easier solution for organisations that know they need some extra support but aren't quite ready to employ staff members yet?
I think that's when partnership working can be really helpful. Think about whether there is an opportunity to have a secondee from another charity or something. So, you're still paying the other charity to give you their staff member for a day a week or something, but it's a nice transition. Or if you just need that extra support, could you share services with another charity or group of organisations? So I think that kind of partnership working in the sector can come into its own here.
Great, thank you very much.
Brilliant, thank you. Thanks for taking that last one, and thanks, Alex, for being really engaged. Thanks to everybody who's been super engaged and asked loads of questions. And just finally, thank you again to Carla, and also thank you to our sponsors, Russell-Cooke, who have made this available. I always have to pause when I say that, because I'm always on the point of saying Russell Crowe, but we're not letting it.
Unfortunately, not as glamorous as Russell Crowe.
And that's the end. Please do check out everything else that we offer, and enjoy the rest of your day.
Thanks.
Thanks very much.